So I want to start just by saying that US privacy law is, I would describe it as messy. They've got unlike in Europe with the GDPR, where all kinds of data are treated and protected the same way. In the US, we have, probably as many of you know, a sectoral approach. So different industries have different sets of rules, different regulators, different things that organizations have to worry about. And unfortunately, for a lot of large organizations, you'll be interacting with several different kinds of privacy laws, several different regulators, because of the different kinds of information you may have. And that's at the federal level. So in addition to laws at the federal level, we also have a lot of laws at the state level. There is literally a book that Lothar Detterman wrote on just privacy laws in California. That's a fairly thick book. So there are lots of laws at the state level as well. You may have heard that in the US, the states are often referred to as the laboratories of democracy. And really that's because of the difference in the way that the culture of the states is. Some states will do things in a very different way from others, and we kind of get to see what all those different versions are, and then over time, hopefully we get to some kind of a consensus. In addition to the federal regulators, we also have state attorney generals, so kind of the chief lawyer of each of the states, who are also responsible for some privacy enforcement. In addition to that kind of enforcement, some of the laws also have private rights of action. So that means that individuals are able to sue companies that break those laws, but the private rights of action don't necessarily cover all parts of the law. For example, with CCPA, the new California law, the private right of action only applies to if there's a data breach. So it gets very, very complicated when you get into a lot of the nuance around the laws. But it gets worse than that, or more complicated than that as well. One of the big challenges is that definitions of common privacy terms vary. Even within California, and I'll mention California quite a bit because a lot of the privacy laws in the US, certainly the ones at the state level, tend to start in California, and then often they will be adopted in some variation by other states as well. So many, with data breach laws, we now have a data breach law in every single state. Many follow the original California law, SB 1386, but there are a lot of nuances in the way that those laws describe what is personal information. And some of them are incompatible with each other. For example, there's a requirement, I don't need to go into the specific states, but some states include a requirement to say exactly what happened in a breach, and some states prohibit companies from actually telling you what really happened. So it makes it very, very complicated if you have a breach that affects multiple states to then work out what to do, which is why there are tools specifically on the market that address that particular concern. There are other California laws that have different definitions of what personal information means. And it means that when you're thinking about your privacy program, when you're trying to even get the basics and say what is personal information, that can often be a challenge. And then one of the more, I would say the newer requirements that came out last year was a so-called do not sell my information. But the way that California has defined sale, it actually captures a lot of other kinds of information where no money is exchanged. Nevada also passed a law last year with a do not sell requirement, but they stuck much more closely to the traditional definition of sale. It's information sold in exchange for money. So even when you're trying to implement, and you can say, well, we've got two different states that seem to have the same requirement, the devil is often very much in the details. One of the other interesting things in the US is that because unlike in European countries, where apart from Germany, there is a single data protection authority at the national level, Germany actually has those at a sub-national level. There are 16 in Germany. But in the US, there really isn't one of those for the reasons that I mentioned previously. So what tends to happen is that the FTC, the Federal Trade Commission, becomes the privacy regulator by default. And their power to do this comes from the FTC Act, which says that they're allowed to regulate unfair or deceptive trade practices. And what that means is that anything where they can be considered that a company does something and someone would say, oh, that's not fair, you can't do that. Or it's deceptive if someone says something and it turns out not to be true, then they can regulate any of those instances. And you may be thinking, well, how does that impact privacy programs? Well, unfair and deceptive, even when you think back to when the FTC Act was passed, and we didn't really have modern privacy in the way we do today, they have expanded that definition to really say that if you collect data that's not in your privacy notice, that could be deceptive. If you say that you're going to be doing one thing with the data and you're not doing it, that could be deceptive. It could be unfair if you're then making choices based on that information. So the FTC has actually prosecuted both privacy and security cases in recent years using this unfair or deceptive standard, which for those of you thinking, well, how do I possibly build a program to actually meet that standard? That's where I'm going to talk a little bit about some of the things that I've done to try and really think about how do we get to a good place with our privacy programs rather than worrying about, do we need to go and find a definition of what unfair means?